I think we're now ready to resume. Mr. Rabinowitz.
My Lord, I'm grateful. Can I then turn to issue 3, which is the question of if there is a creditor duty, when is it triggered? And can I begin perhaps by reminding the court about the various positions that have emerged? First, it is common ground that the duty is not triggered if the company is amply insolvent. Is amply solvent, I'm sorry. That's accepted by BTI, paragraphs 99 and 101 of their case. And then, of course, the Court of Appeal concluded that the creditor duty is triggered if the company is actually insolvent or if insolvency is probable, that is to say, more likely than not, and the director has the requisite knowledge of that. And that is paragraph 220 of the Court of Appeal judgment, page 217. Next, as the court knows, BTI seeks to persuade this court that the Court of Appeal was wrong about this and that the duty is also triggered where there is a real risk of insolvency, even if, this is a necessary part of this case, even if that risk is unlikely, and indeed even if that risk will only materialize, if at all, it's unlikely, after a considerable period of time. So that's the BTI position. And then finally there is our position, which, as the court knows, is that the duty is triggered only where a company is actually insolvent or when the insolvency is imminent. And we further submit in the alternative that if we're wrong about this, then we say respectfully that the Court of Appeal was plainly right to hold that at least likelihood of insolvency is required, and we respectfully submit that the Court of Appeal was correct to reject the real risk test for which BTI contends. So those are the various competing positions, and what I propose to do, subject to the court, is to deal first with the test for which we contend, that's actual imminent insolvency, and thereafter to say something about Malone Friend's criticism of the Court of Appeal for rejecting the real risk test that he proposes. Before I do that, can I just make 4 brief overarching observations which we submit have a bearing on the trigger issue? The first observation is this. As the court will be aware, and as I've already noted, there are various statutory and common law rules that protect creditors, even in a case in which the creditor duty has not been triggered. For example, as we've discussed, Section 214 and 219 of the Insolvency Act, which the court has seen, as well, obviously, as Part 23 of the Companies Act as well. And this, of course, is over and above any contractual protection which creditors may secure from the company, such as a lien or some other form of security. The second observation is this. The trigger event for the creditor duty, whatever the precise test, might be described, as the learned judge recalls was done at trial, as being a transformative event. That's in the judgment of Mrs. Justice Rose, as she was then, paragraph 461, page 347. And what is meant by describing this as a transformative event is that before the creditor duty is triggered, it is common ground that the directors are required to act in the interests of the shareholders as a whole, not the creditors, taking other interests into account only as part of this overall duty to act in the interests of the shareholders. And as we understand it, BTI accepts that once the creditor duty is triggered, it is triggered in relation to all decisions made by directors, not just decisions to pay dividends. So it is not possible to say that the duty can be triggered in respect of dividends alone, and indeed Malone Friend does not say that. And we respectfully submit that this is important because it means that once the duty is triggered, the director's ordinary decision-making process is potentially altered in relation to every single decision they make, not just the decision to pay dividends. And if, because of the creditor duty, a decision they would otherwise have been fully able to make is attacked, then of course the directors are at risk of personal liability, and on BTI's case, their decision cannot be ratified even by the shareholders acting unanimously. And my lady, my lords, given that the duty, once engaged, has such wide-ranging consequences, we do say that it should not be lightly engaged, and we also say that, having regard to the serious and transformative nature of the shift in responsibilities, it is important that a clear test is required, so that directors know precisely what they can and cannot do. The third observation we make, which really follows from the second, is this. Leaving aside for the moment the creditor duty, the ordinary principle is, of course, that directors are required to act in the interests of shareholders as a whole. And we've already seen in the context of issue 1 that this was the common law rule, and it is also what section 172(1) says. And I've already made the point that the interests of other constituencies, referred to in section 172(1), are relevant only insofar as they are consistent with the primary duty of directors to promote the success of the company for the benefit of the members. The shareholder would be entitled to ratify any failure to have regard to such interests, precisely because those interests are subordinate to the primary duty to promote their own interests. And of course, the interests of creditors may well be relevant in the same subsidiary way under section 172(1). But on BTI's case, the creditor duty, if it exists, does more than arise in circumstances where it has to be taken into account, because it is said this is capable of modifying the ordinary duty. And so the court will recall that I made this point where I addressed issue 1. If the creditor duty is to exist at all, it can only do so on the footing that creditors are different in some respect from those of other constituencies. And the touchstone or trigger for the creditor duty cannot simply be that the interests of the creditors are at risk by decisions made by directors, because that would be equally true of all the other constituencies listed in section 172(1). But it is common ground that there is no duty of the kind for which BTI contends as regards those other constituencies. So that's the third observation. The fourth observation is this. Even if the court is against me on issue 1, and that is the assumption that one has to make at this stage of the analysis, it is plain, again, as I noted when addressing the court on issue 1, that the creditor duty is, to put it at its lowest, controversial, and has been strongly criticised by distinguished judges and scholars. It also raises what Lord Justice David Richards described as difficult policy issues. That is at paragraph 209 of his judgment, page 215. And we would respectfully suggest, therefore, that even if the court is persuaded that the creditor duty does exist, the court should nonetheless be slow to accept my learned friend's invitation to construe the duty as broadly and expansively as he asks you to do. So those are the 4 overarching observations that we make about this issue. And against that backdrop, can I then turn more directly to deal with our primary case as regards issue 3, which is that contrary to the conclusion reached by the Court of Appeal, the duty is not triggered except by actual or imminent insolvency. And just pausing there, if the creditor duty exists, then we submit that to identify when it should be engaged, one first has to ascertain why it exists. In other words, what is the rationale for the duty, which is, of course, the issue that the court considered under issue 1. And as Lord Justice David Richards pointed out in his judgment at paragraph 217, page 217, the only authoritatively established rationale for this duty that has been suggested in this jurisdiction is the quasi-proprietary rationale identified in Kinsella and West Mercia, which we have looked at. I'm not going to take the court back to those authorities. We've already spent time on those authorities, which I would just note are both authorities in which the company was actually insolvent. And they're both authorities in which the court identified the trigger as actual insolvency. And indeed, in West Mercia, the court, it's perfectly clear that there was to be imminent liquidation. And I say that because, without inviting the court to go back to this now, at page 693H, Lord Justice Dillon mentions that there had already been consultation with a professional insolvency advisor in West Mercia. So that is the rationale, and indeed the only rationale which has been put forward for this the existence of the creditor duty. That's to say the quasi-proprietary rationale. That creditors may, through the mechanism of imminent liquidation, obtain the assets currently under the management of the directors. My lady, my lords, if that is the rationale for the creditor duty, then we submit that, having regard to that rationale, the duty cannot be engaged prior to actual insolvency, because we would submit it is obviously not the case that the assets of a company that is cash flow solvent and also balance sheet solvent belong, even in a practical sense, to its creditors rather than shareholders. And again, as I've already noted, Lord Justice Dillon in West Mercia refers only to actual insolvency. as indeed was what was referred to in Kinsella. And it follows, just having regard to something my learned friend says in his case, at paragraph 92, my learned friend suggests that the actual insolvency trigger is, as he puts it, unsupported by any judicial opinion. With respect to my learned friend, that is a surprising submission in circumstances where West Mercia itself identifies that as the trigger. Not only is that identified as the trigger in West Mercia itself, but there is at least one other case where the actual insolvency trigger is identified. That's the Court of Appeal in the Stern case. The Vice-Chancellor, Sir Andrew Morritt, expressly posited the duty by reference only to actual insolvency. For the Court's note, that is page 2350 at G to H, paragraph 32. And I can also tell the Court that the Court of Appeal in the recent Stanford decision, which is in the Additional Authorities Bundle, tab 3, page 5201 at 5208, paragraph 32, the Master of the Rolls again expressly identifies the duty as arising when the company became actually insolvent. Now, so those are authorities which do, contrary to what my learned friend has suggested, actually support the actual insolvency trigger. So far as the other authorities are concerned, and my learned friend has referred to wealth of authorities, that is true. As Lord Justice David Richards pointed out, this is at paragraph 195 of his judgment, page 211, and we say this is with respect correct. There is not a single English authority that, as he put it, is clearly based on the proposition that something less than actual insolvency is sufficient. We acknowledge, as the learned Lord Justice also pointed out in the same paragraph, that many of the decisions suggest, or at least assume, that something short of insolvency does suffice. But as we've already submitted, the vast majority of those cases are first instance decisions, and the relevant observation in most of those cases was obiter, and none seek to explain how a pre-insolvency trigger is consistent with the quasi-proprietary rationale. Now, I'm not sure that the Court will be assisted by being taken through those cases, and I wasn't proposing to do so. We are content with respect to adopt Lord Justice David Richards' analysis of those authorities. Just in terms of the earlier authorities, I would just note that whilst the observations made in this court in Bilter, although not, I would add, in Canberra, proceed on the basis that something less than actual insolvency may be sufficient, in neither case did the point actually arise for decision, and in both cases we submit that the relevant observation was obiter. And in fact, in Canberra, my Lord Hodge, in any event, referred only to actual insolvency, not to something short of it. And indeed, in Bilter, which is the other case that arose before this court, the company in question was actually insolvent. Now, the same point can actually be made in the two Court of Appeal cases on which my learned friend relies. That's to say the Horsley and Waite case, which is page 562, and the Brady case at page 1490. In both cases, the relevant observation was obiter, and this is common ground, at least so far as Horsley is concerned. Brady was actually concerned with a different issue altogether, and as I say, neither explains with respect how the duty can arise before actual insolvency consistently with the quasi-proprietary rationale. Now, the learned friend in his case, written case, actually accepts that the quasi-proprietary rationale does not, as he put it, and these are these words, apply in full prior to actual insolvency. But he contends, and again to use his words, that there is a real risk that it will be applicable possibly sometime in the future. That's the way he puts it. And therefore, he suggests on that basis that the duty should be triggered before actual insolvency. And we respectfully submit that this is a non sequitur. If, as my learned friend appears to acknowledge, the rationale for the duty is not engaged before actual insolvency, the fact that it may be engaged in the future is not, we submit, a reason for the duty to apply now. Now, the Court of Appeal, as this court will have picked up, gave a different reason for rejecting our submission, that actual insolvency is required. And can I invite the court just to glance at paragraph 218 of the judgment of Lord Justice David Richards. That's at page 217. As Lord Justice David Richards says, an inconsistency might be said to exist between the rationale and the many statements that extend the trigger to a state of near insolvency. I do not, however, think that there is an inconsistency. The precise moment at which the court becomes insolvent is often difficult to pinpoint. Insolvency may occur suddenly, but equally the descent into insolvency may be more gradual. The qualified way in which judges have expressed the trigger, I'm among them, reflects that the directors may often not know, nor be expected to know, that the company is actually insolvent until some time after it has occurred. For this reason, among others, a test falling short of established insolvency is justified. And we, with respect, acknowledge that there is some force in the observation that the learned justice there makes. But it is, we suggest, a point of practice, not principle, because the fact remains that the assets of a company that is both balance sheet and cash flow solvent cannot, even in a practical sense, be treated as belonging to its creditors. And, my lady, my lords, what paragraph 218 of Lord Justice David Richards' judgment does not explain is what conceptual or principled, as opposed to purely pragmatic reason there is for extending the duty to pre-insolvency cases, if the rationale for the duty is quasi-proprietary. But even the pragmatic point that the learned Lord Justice makes, which I have acknowledged does have some force, is a point that can only justify, at most, extending the trigger to cases just short of insolvency. That is to say, where insolvency is imminent in a temporal sense. And even that extension, we would submit respectfully, would be justified purely as a prophylactic rule to prevent directors, when insolvency is around the corner, from ignoring the interest of creditors just before they come knocking on the door. An extension of that sort could conceivably be justified by the same quasi-proprietary rationale, even if the justification is one of pragmatism rather than principle. I'm not proposing to take the court to them, but I would note that insolvency was in fact imminent in nearly all the cases that suggest that the duty may be triggered before actual insolvency. For the court's note, we've provided the references to these cases and the passages which demonstrate that it is the imminence of insolvency that led to the duty being triggered at footnote 84 of our written case at page 144. In other words, while glosses and metaphors are always dangerous, the duty has generally been found to arise when insolvency is imminent, in the sense that it is in the air, and the directors must be thinking, as it were, of picking up the phone to an insolvency practitioner. Now, the Court of Appeal, in a single passage, this is at paragraph 219, rejected that submission. And can I invite the court to go to that? It's at page 217. So paragraph 219 and page 217. And Lord Justice David Richards says this: I consider there to be a problem with formulations in the second category, such as being on the verge of insolvency, because they suggest a temporal test. If the test is that insolvency is imminent, or if similar words are used, it suggests that actual insolvency will be established within a very short time. That may well describe many situations in which the duty is triggered, but it does not or may not cover the situation where, although the company may be able to pay its debts as they fall due for some time, perhaps a considerable time to come, insolvency is nonetheless likely to occur, and decisions taken now may prejudice creditors when the likely insolvency occurs. And it is, we submit, notable that this passage nowhere explains how the duty arising in the example given there could possibly be consistent with the quasi-proprietary rationale. If the company is solvent and unlikely to become solvent anytime soon, insolvent anytime soon, and will only become insolvent, if at all, say in 10 or 15 years' time, then there can, with respect, be no possible basis for invoking the duty. The mechanism of liquidation, which is what Westmoreland says triggers the prospective interest of creditors in the company's assets, is potentially a decade away. And our case is therefore that the duty is not triggered unless the company is actually insolvent, or insolvency is both probable and imminent. And that's why we, with respect, suggest that the Court of Appeal were wrong to reject our imminence test, even if they were right to reject our actual insolvency test, because for prophylactic reasons. The prophylactic reasons can only take you so far, and in our respectful submission, they don't take you beyond the point of imminence. Now, if contrary to that submission, this court concludes that neither actual nor imminent insolvency is required, then the choice is between the test adopted by the Court of Appeal, namely that insolvency must at least be probable, even if it is not imminent in a temporal sense, and the test for which my learned friend contends, namely that even an unlikely risk of insolvency is sufficient, as long as it is something more than remote. And in our respectful submission, the Court of Appeal was plainly right to reject that test. And that is so, we would respectfully submit, for a number of reasons, which mostly correspond to those given by Lord Justice David Richards. And perhaps I can just identify them before addressing them in turn. First, the real risk test is wholly inconsistent with the rationale for the creditor duty. That's our first point. I'll come back to that. Second, the real risk test is not supported by a single English authority. Third, the real risk test has no support and indeed is positively contradicted by the pre-legislative material on which my learned friend relies. Fourth, it would, as the Court of Appeal rightly said, have a chilling effect on entrepreneurial activity. And fifth, if notwithstanding all of those points, the Court is persuaded that there is something to be said for the real risk test, then we also respectfully submit that the decision whether it should actually be adopted is preeminently one for Parliament, because it raises difficult policy issues which this court, with respect, is not in the best position properly to assess. So turning then to the first point, that the real risk test is inconsistent with the rationale for the creditor duty. As I've already noted, Lady my Lords, the appellant accepts that the quasi-proprietary rationale is inconsistent with the duty arising prior to actual insolvency. I've given the court the reference to that already. It goes on to say, as I've said, that the real risk test is nevertheless justified because there is a real risk that the rationale will be engaged in the future. But as I've already submitted, that with respect is a non sequitur for the reasons I've given. And we would respectfully submit that Lord Justice David Richards was therefore clearly right to say that BTI's test would be a new test that the quasi-proprietary rationale is not capable of supporting. That, for the court's note, is at paragraph 200. The Court of Appeal judgments, page 213. We would respectfully submit that BTI's approach at times is simply to assert that the real risk test is appropriate because they say it is desirable that creditors are protected when there is a genuine risk of insolvency. And one finds this, for example, for the court's note, at paragraph 98A of my learned friend's case, page 78. And we would respectfully disagree with that, because it cannot be right to say, we say, that the touchstone for the creditor duty is simply that the interests of creditors are at risk because of decisions made by directors, because that is also true for all sorts of other constituencies, such as employees, suppliers, and the like, and customers, in respect of whom it is common ground there is no equivalent duty. So creditors must therefore be shown to be different in some relevant respect. And I know I'm repeating points I've previously made, but they're relevant in this context as well. And that can only be having regard to what is said in the authorities on the basis that, unlike these other constituencies, they are entitled in a practical sense to the company's assets through the mechanism of insolvency. And that rationale does not begin to support extending the duty to an unlikely, and I repeat, unlikely, non-imminent risk of insolvency, merely because it is something more than remote. That's the first point. Our second point, as I've already noted, is that the real risk test really has no support in the authorities. In the interest of time, I'm not going to take the court through the authorities, but we respectfully adopt Lord Justice David Richards' analysis of them between paragraphs 129 and 192 of the Court of Appeal judgment. That runs from page 193 to page 211. And we also respectfully adopt his conclusion at paragraph 193, which may be worth turning up. That's at page 211. Can I invite the court to turn that up, please? Paragraph 193. Court has this. As will be apparent from comments made in the course of reviewing the authorities, I am satisfied that they do not establish the trigger for which Mr. Thompson contends. In a few instances, notably in calls, the trigger is expressed in those terms, but consistently in the great majority of cases, up to and including Bulter and Nazar, it is expressed in much less expensive terms. It may be that in those few cases, as the judge in the present case thought, it was just a different way of saying the same thing, but that is of no use to Mr. Thompson. And can I just ask the court, whilst we have the judgment open, just also to look at paragraph 172 at page 205. Where Lord Justice David Richards says this, these authorities at first instance provide some support for the proposition that something short of actual or established insolvency will be sufficient to trigger the creditor's interest duty. But none of these English cases provide any support for the formulation for which BTI contends, that there is a real as opposed to a remote risk of insolvency. And we respectfully adopt that. Now, my learned friend refers, this is at paragraph 125 of his case, the court's note, page 89, to 4 Australian authorities, which he says support the real risk tests. And again, my lady, my lords, although the phrase real risk is used in those cases, those authorities we submit do not in fact support any suggestion that the duty should be engaged in respect of an unlikely, non-imminent risk arising out of a long-term liability for which the company has made proper provision, merely because the risk is something more than remote. For the court's note again, we've addressed those cases at paragraph 96 of our written case, page 146, particularly footnote 96 on that page. And we would respectfully adopt what Lord Justice David Richards said about them in the Court of Appeal judgment between paragraphs 181 and 191. That's page 207 and following of the judgment. So that is the second point. There is no authority which supports Millennium offence test. Third, and contrary to what my learned friend suggested at paragraph 124b of his written case, it's page 89, the real risk test also has no support in the pre-legislative materials to which my learned friends have referred. As the court, and perhaps especially my Lady Arden, will recall, the 2006 Act had its origin in the Company Law Review that was commissioned by the government in early 1998. And the Company Law Review Steering Group, or CL, not sure it's shorter to say CLRSG, but the Review Steering Group, produced at least 9 substantial consultation documents and a final report in June 2001 that considered various aspects of company law, including the duties of directors. And if I can ask the court to turn first to the strategic consultation document issued at an early stage in the review, so that's March 2000, the court will have this at page 3920. And can I invite the court to look, please, at first at paragraph 2.11, starting at page 3943. Just the first 2 sentences. A very substantial majority of responses favoured retaining the basic rule that directors should operate companies for the benefit of members, i.e. normally shareholders. However, there's also very strong support for the view that this needed to be framed in an inclusive way. If one then goes down to paragraph 212 on the same page, similar substantial majority also strongly opposed directors being empowered or obliged to set interests of others above those of shareholders where wider interests required. The objections were largely those referred to in the Strategic Framework Consultation document, in particular that this would impose a distributive economic role of directors in allocating benefits and burdens of management of the company's resources, that this role would be uncontrolled if left to directors in the form of power or discretion, and that a similarly broad role would be imposed on the judges if the new arrangements took the form of an enforceable obligation conferring rights on all the interested parties to argue for their interests in the court. Very few of those who did favour this pluralist approach favoured giving the various constituencies concerned such rights. This confirmed our initial view that such enforceability was not a practical way forward. The supporters of this pluralist approach mainly wanted either a powerful Secretary of State to intervene or a consultative system. Some who argued for this approach did so as a means of promoting change in areas usually regarded as wider than company law, e.g. recognition of the environmental, social, or ethical issues. These arguments were balanced by a majority view that such issues were better dealt with by specific legislation applying to business generally, partnerships and sole traders as well as companies. And then if I can invite the court to go next to paragraph 3.35 at page 3961. In general, we believe that attempting to graft a continental stakeholder model of directors' duties into a very different cultural and political economic environment would not produce the benefits intended by its advocates and would give rise to risks of reduced accountability, which we do not believe are necessary, giving the potential for organic development of our present rules and practices along the lines we propose. Just to be clear, this is generally about the pluralist view. It's not about the creditor duty, and I want to make that clear. But there was a rejection of this pluralist view generally. Can I then invite the court to go to 3976, where one has paragraphs 3.72 and 3.73. So picking it up at 3.72, 3976, we've considered the case for adding a sixth principle. See the heading, a general principle in relation to creditors. We've considered the case for adding a sixth principle requiring directors to consider foremost the interests of creditors in circumstances where the company is insolvent or threatened by insolvency. A number of British and Commonwealth court judgments have suggested that such a principle exists. This looks attractive, but in reality the cases seem capable of resolution on the basis of other principles and have been strongly criticised on these grounds. Creditors should have a remedy in a winding up or on the basis of their contracts, and the effect of insolvency law should be to ensure that the prospect of personal liability to them on the part of directors has a salutary deterrent effect when the company is threatened with insolvency. Creditors' interests are already properly included within the inclusive loyalty principle as an ingredient of company success, in company success, principle 1b. Enactment of such a sixth principle also seems to cut across section 214 of the Insolvency Act, itself backed up by the threat of disqualification, which enables a director of enables a liquidator of a company in insolvency winding up to recover a contribution from a director who failed to take necessary action to protect creditors when insolvency was inevitable. This is a separate and detailed overriding provision, which we see no case for changing. We are therefore inclined to reject the case for a sixth principle to have regard to the creditors as such, though we believe ratification cases may be different. It might well, however, be appropriate to include in Form 288 a separate warning that special principles become relevant when a company is threatened by insolvency. We would welcome views on this provisional conclusion. So that's the consultation document. Then in November 2000, one sees, when one goes to the report produced by CLRSG at this time, which the court has beginning of page 4047. So here is the report, first report produced, I think, in November 2000. And one sees in this that the CLRSG took a similar view against codifying the creditor duty. If you go to, I should have said page 4083, I'm sorry. One sees here that the the CLRSG took a similar view against codifying the creditor duty, and although they considered that the creditor duty did exist, they made no reference whatever to a real risk. Can I invite the court just to look at paragraph 312? It's really the last 8 lines of it. It is generally agreed that the duties must be subject to the overriding duty of directors towards creditors in an insolvency situation, but also that it is undesirable to lay down any detailed new rule in this area. The law is developing, and there is already a carefully balanced statutory provision which operates ex post in a liquidation. in Insolvency Act 1986, Section 214, wrongful trading. We propose that this issue should be dealt with in a general provision in a statement, making it clear that the duties operate subject to the other provisions of the Act and to the supervening obligations to have regard to the interests of creditors when the company is insolvent and or threatened by insolvency. We propose that the details should be explored with the draftsman. And then we have the final report. So one sees no reference whatever to the real risk idea. If I can invite the court to go to the final report, Mr. Thompson took you to this. That's at page 805. And I invite the court to go back, I think, to go to paragraph 3.8 first, at page 852. And at paragraph 3.8, one has the review, or the group referring to the proposed statement of the duty of loyalty, making clear that the obligation of each director to act to serve the purpose of the company is laid down, must require them to recognise companies need to foster relationships with employees, etc. Then if you go to paragraph 312 on page 853, I think the learned friend took you to this. Can I think the court may already have seen it, but can I just take the court through it again? In providing a high-level statement of directors' duties, it's important to draw the directors' attention to the different factors that may be taken into consideration when the company is insolvent or threatened by insolvency. Failure to do so would be misleading to directors by omitting an important part of the overall picture. When we consulted on our initial draft statement, we noted that including in the statement itself a specific duty in relating to creditors which would displace partially or entirely the normal shareholder-oriented loyalty duty at the onset of insolvency raised a number of technical problems. We were also concerned that such inclusion risks cutting across insolvency law. We proposed to resolve the issue by including a separate warning to directors that special principles become relevant when a company is threatened by insolvency. And 313, while many supported this approach and it remains feasible, arguments were voiced in favour of including in the statement a duty towards creditors applicable in cases where insolvency was imminent. There was also criticism that the responsibility of company management not to abuse limited liability had been given insufficient attention. By simplifying and clarifying the law and removing unnecessary restrictions, we are making such limited liability more accessible for business. Furthermore, we now believe that the technical difficulties can be resolved. With all these factors in mind, we now propose that they be incorporated in the statutory statement principles requiring directors to have regard to the interests of creditors in relation to threatened insolvency. The key issue is this: when should the normal rule that a company is to be run in the interests of members or shareholders be modified by an obligation to have regard also to the interests of creditors, or in an extreme case by an obligation to override the interests of creditors of members entirely, to the extent necessary to ensure creditors have the best protection? Can I just then invite the court to go to look at paragraph 317 on the top of page 855. However, arguably, directors should also be bound to take a balanced view of the risk to creditors at an earlier stage in the onset of insolvency. Such a principle has been recognised in some Australian cases and in one case in our Court of Appeal. It would require directors, where they know or ought to recognise that there is a substantial probability of an insolvent liquidation, to take such steps as they believe in their good faith judgment appropriate to reduce this risk, without undue caution, and thus continuing also to have in mind the interests of members. The greater the risk of insolvency in terms of probability and extent, the more directors should take into account creditors' need and the less those of members. At the point where there is no reasonable prospect of avoiding insolvent liquidation, the interests of the creditors become overriding. So, substantial probability of an insolvent liquidation. And then just carrying on with 318 and 319. My Lord, you're on mute.
I'm just wondering why we're being taken to all this. What does it matter? We know what Parliament enacted.
That is true. We're being taken to this because my learned friend says he seeks to rely on these pre-legislative materials as in some way supporting a real risk case. The point I'm trying to make...
But pre-legislative materials are irrelevant unless they provide some assistance in interpreting what Parliament enacted.
I entirely accept that, my lord. I'm responding to my learned friend's point. The only thing I would say about this is that the highest, even the steering group was prepared to go, was a test where the creditor's duty was triggered where there was a likelihood of insolvency, substantial likelihood of insolvency, substantial probability of insolvency. And that is the high water mark of the review group, which was rejected by Parliament on the basis that, as my lord says, it had a chilling effect. Now, the short point, therefore, and my lord's right, I'm sorry I took so long about it, we know in the white paper to July 2008 that the government rejected the draft clause 8, which had put this in terms of probability. And we know that they rejected it because of the chilling effect, which is what is referred to in 3.19. So, as I say, the reason I've taken up time on this is really to respond to my learned friend's suggestion that he gets any assistance at all from this pre-legislative material or from what the steering group thought. The position is quite to the opposite. It is completely against any test which goes beyond likelihood. And even that was rejected by the government. For, insofar as that matters to the court in moulding, if this is where we are, the trigger, that is, with respect, all I need to say about it. So, as I say, the learned friend's test is more expansive than even a test that the review group proposed, and certainly that even the government then rejected. So that's our third point about pre-legislative materials. The fourth point we have is this. We respectfully submit that Lord Justice David Richards was entirely right to say what he did at paragraph 200 of the Court of Appeal judgment. Can I invite the court to go back to that? It's at page 213. Paragraph 200, and he's addressing the learned friend's test. He says at paragraph 200, these difficulties do not mean that it would necessarily be wrong to adopt the test proposed by BTI, but it would be a new test not anchored to the quasi-proprietary interests of creditors in the assets of an insolvent company. It is a test that predictably would have a chilling effect on entrepreneurial activity, when such activity is the underlying purpose of most registered companies. And one finds a similar point being made by Mrs. Justice Rose, as she was then, in the decision of the first instance court. And can I just take the court to that as well? Page 354. Paragraph 479. In the instant case, there was a real possibility that AWA would never become insolvent or even close to insolvent. The best estimate of the Fox River liability might turn out to be accurate, in which case the company's assets would be sufficient to meet the liability even without the need to rely on proceeds from the historic insurance policy. It cannot be right that whenever a company has on its balance sheet a provision in respect of a long-term liability which might turn out to be larger than the provision made, the creditor's interest duty applies for the whole period during which there is a risk that there will be insufficient assets to meet that liability. That would result in directors having to take account of creditors rather than shareholders' interest when running a business over an extended period. This would be a significant inroad into the normal application of directors' duties. To hold that the creditor's interest duty arises in a situation where the directors make proper provision for a liability in the company's account, but where there is a real risk that the provision will turn out to be inadequate, would be a significant lowering of the threshold as currently described and applied in the cases to which I referred. I can see no justification in principle for such a change. Can I, just having shown these passages to the court, just deal with what my learned friend says in response to these criticisms? Now, one point he takes is to suggest that the trigger for the duty is not purely objective. And that's in paragraph 112A of his case, page 83. He says it is triggered only when the director knows or should know about the risk of insolvency, and presumably on his case, whether, although unlikely, it may still be real. But this, with respect, is no answer to the chilling effect point. Because whether the trigger is subjective or objective, directors will usually act on the basis of advice that they receive. And no director would be advised, if the test is set as low as anything more than a remote risk, no director, if that is the test, would be advised if the test is set as low as anything more than a remote test, that the duty has not been triggered, except perhaps in the clearest case. The director is simply not going to do anything where he is exposed. And that, of course, is the point that Lord Justice David Richards made at paragraph 199 of the judgment. And can I again invite the court to go back to that, page 212, paragraph 199 of the Court of Appeal judgment. Just picking this up, it's the bottom of page 212. The reconciliation of the duty under section 172 and the creditor's interest duty will, unless creditor's interests are paramount, present difficulties. Take the case of a company which is solvent and has cash resources available to meet a liability due to mature in 2 years' time. The interest of creditors would be served by retaining the cash until the liability matures, investing it in the meantime in risk-free assets. The company has an opportunity to invest the funds in a business venture that carries significant risks and rewards. It would not be a foolhardy investment, but if the real risk of failure occurs, it is the creditors who will lose. If BTI submissions were accepted, I do not believe that in such circumstances, directors could be advised that they would not run any real risk of being held to have acted in breach of duty. Of course, there could be an argument about it, but in the real world, directors do not usually court these personal risks. And we respectfully adopt that. Now, Malone and Friends' second suggestion in response to this is to say that the duty is, as he puts it, relatively undemanding if the company is not actually insolvent, because it is said the interests of creditors merely need to be taken into account and are not paramount. And that, for the court's note, is what Malone and Friends says in his written case at paragraph 75, that's at page 72. But with respect to Malone and Friend, again, that does not assist. Indeed, we would submit that, in fact, it makes the task of directors more, not less, difficult. Because he or she has to take into account two conflicting sets of interests, not merely one, as they usually do under section 172(1). And it is not difficult to think of cases in which having to balance these conflicting sets of interests, rather than just promote one, could give rise to real difficulties for directors. Indeed, a good example is to be found at paragraph 199 of the Court of Appeal judgment, which is the passage I just took the court to. In that example, BTI accepts, indeed contends, that the directors are not entitled to invest the cash in the business venture unless the risk involved in that venture, I think what it says is normal, I think is the phrase they use, as opposed to abnormal or excessive. This is again BTI's language. It's okay to take the risk if it is normal. It's not okay to take the risk if it is abnormal or excessive. That's the language that they use at paragraph 131 and 141 of their written case, pages 91 and 95. But with respect to my learned friend, those propositions of how the test works are much easier for a litigant to say than for a director to do. In practice, the danger of a director having to worry about whether someone's going to regard this as excessive as opposed to normal or abnormal as opposed to normal, the danger is that the director would perfectly reasonably simply err on the side of caution to avoid the risk of personal liability. I mean, why would they take a risk of personal liability? To which, on BTI's approach, shareholder ratification is no longer a defence. So the choice is, do I make an estimate of is this normal, abnormal, normal, excessive? If I go one route, I'm going to be personally liable, and that can't be ratified. I know what I'll do nothing. Hence the chilling effect. And that, as the court will recall, is the point made by the Company Law Review Group at paragraph 319 of its final report, in the context of an even stricter trigger than that for which BTI proposes. That's the unlikelihood trigger. So we would respectfully submit that BTI has not identified any satisfactory answer to the chilling effect points. Our fifth and finally, if, notwithstanding all of the points I have sought to make, the court is satisfied that there is something to be said for the real risk tests, we would respectfully agree with the point made by Lord Justice David Richards in the Court of Appeal at paragraph 215 of the judgment, page 217, that it is not a test that it is appropriate for the courts to introduce as a development in the common law. Can I invite the court to turn that up? Paragraph 215 at page 217. My judgment, says Lord Justice David Richards, the test of a real as opposed to a remote risk of insolvency is not part of the present law as regards the creditor's interest duty, and it would not be appropriate in light of the policy considerations and other provisions of the Companies Act to which I've referred for the court to introduce such a test as a development of the common law. And that is because, my lady, my lords, it is virtually common ground that the only reason of principle as distinct from policy that has been identified in the authorities for the creditor duty, namely the quasi-proprietary rationale, does not support the real risk test at all, and that BTI's case rests in reality entirely on the assertion that to introduce such a test would be desirable simply as a matter of policy. We question that, but even taking it on its own terms, as the court will understand, the respondent's position is respectfully to contend that it would not be so desirable, not least because of the chilling effect danger. Together with it is submitted the fact that there is no reason why creditors should be placed in a privileged position by comparison to employees or other constituent companies, together with the fact, as I explored in issues 1 and 2, that it will serve simply to unbalance the careful balance which has been struck by the legislature in the various statutory provisions which operate in this area and when they operate, for example, section 239. But in any event, my lady and my lords, what is beyond argument we would respectfully submit is that the issue is one that would raise difficult policy issues, many of which are identified in the various CLSRG reports and indeed in BTI's case. For example, BTI, in its written case, invites this court to express a view or to come to a view about such matters as, for example, the relative bargaining power of corporate creditors. That is what it says at paragraph 109A, page 82. It invites the court to come to a view about information asymmetry and transaction costs involved in obtaining security. That's paragraph 109B, at page 82 of its written case. It invites the court to come to a conclusion about the propensity or otherwise of company directors to abandon a viable business prematurely, paragraph 144, page 96. And it invites the court to come to a view as to the likelihood or otherwise of the creditor duty inhibiting entrepreneurial activity. That's paragraph 124B at page 89. And these we would respectfully submit are not matters that a court, as distinct from, for example, a body such as the CLRSG, which can have consultations, 9 consultations or whatever, can properly test. And for that further reason, we would respectfully invite the court to reject the test for which my learned friend contends. Now, I should finally just mention that my learned friend takes two further points in support of the real risk test. First, he gives a series of examples which he says support the test. That's at paragraph 127 of his case at page 91. And second, he says that the fact that a section 423 finding was made against Sequana in this case itself shows that the real risk test was appropriate. That's paragraph 139 of his case, page 94. With respect, we would respectfully submit that these points do not assist. In the interest of time, I would simply refer the court to our written case, where we deal with both of these points at paragraph 99 and 100 respectively. Now, subject to the court, that is all I was proposing to say about issue 3. I'm conscious of the fact that it's taken me a little less time than I thought it would to get through this. One possibility is that I go back and deal with the point about section 172.3. Another possibility is that the court has heard enough from me on that and is satisfied with the answers I've given and can hear from my learned friend on that. But as I say, I'm not proposing to use another half an hour just because I have it. Those were my submissions on issue 3, subject to any questions that the court had. So sorry, I don't know if I cut across anyone. Just drawing the various threads together, my lady, my lords. Given what is common ground, it follows, we submit, that this appeal would fall to be dismissed if the court is satisfied that the creditor duty exists, is capable of applying to lawful dividends, is triggered by a real risk of insolvency, even when insolvency is unlikely, and will materialize, if at all, only at some indefinite point in the future, potentially after a considerable period of time. And if, contrary to our submissions, my lady and my lords, you do reach that conclusion, then this case would fall to be remitted to the Chancery Division, because contrary to what my learned friends appear to be suggesting at paragraph 2 of their case, the learned judge did not make any findings at all about whether there was a real risk of insolvency at the time the May dividend was paid. And we certainly do not accept that there was, not least because, as the court may recall, the learned judge found that AWA had a substantial buffer over and above the FRS 12 compliant provision in the form of the historic insurance policies, which were thought to be worth $100 million. In other words, the risk may well have been remote. For the court's reference, that's paragraph 425 of the judge at first instance judgment. In addition to this, if the court is against me, there would also be further consequential questions, such as whether the duty was breached. There would be questions as to relief under section 1157 of the 2006 Act, and questions about the remedy would also arise. But of course, as my lady and my lords are aware, we respectfully submit that the appeal should in fact be dismissed, in which event none of this would arise. And unless there is anything further with which I can assist the court, happily finishing early rather than late, those are our submissions, subject to any questions that the court has.
Thank you very much, Mr. Rabinowitz. There don't appear to be any questions at the moment, at any rate. So we'll turn to Mr. Thompson for his reply.
My lord, thank you. My lord, my lady, thank you very much. Now, I'll try, if I can, to deal with the points that my learned friend made insofar as I need to, in approximately the order in which he dealt with them. Obviously, a few of them came up more than once. Now, the first point is the criticism levelled at us as regards the way in which it suggested we dismissed old authorities simply on the basis of their age. The position here is that we don't say that at all. We make a couple of points. The first is that as regards any case decided before there was even any suggestion of a creditor duty, that is a duty, that is a modification of the duty owed to the company, requiring creditors' interest to be taken into account. At that stage, any ruling by a court at that point is of very limited authority, if indeed any, in our submission, on the matters that are presently before the court, simply because a court at that stage has inevitably not given any consideration whatsoever to this aspect of the content of directors' duties. It's not enough to say on the respondent's part that because a case might have been decided differently, if the law is now as we say it is, on the basis of claims that were never actually advanced, that's of no assistance at all. Now, if such cases arising long before the issue of the creditor duty arose actually identified some principle which was inconsistent, arguably, with the creditor duty, then of course that might be of relevance. But that's a very different thing to simply saying, as the respondents do, that historical cases would have been decided differently had the creditor duty been recognised at that stage. And if there is any such principle in any earlier case, then the case is not directly authority against the propositions that I'm currently advancing. It simply identifies a principle which has to be taken into account in deciding the questions that are now in front of the court. That's the first point we make. Now, the second is to similar effect in this sense that the other important distinction, or the important point that has to be borne in mind in examining any of the Victorian cases referred to, is that it is absolutely plain that at that point, company law and the courts invoked a very different conception of the company and its relationship with shareholders and others. And that is something that is made absolutely clear, we say, through the provisions of the Companies Act 2006, as explained in the Seeley article that I referred to right at the outset of my submissions. Companies Act 2006 really is a major reworking of company law, and one cannot just look past that in considering the effect of cases that long preceded it. Now, as regards the effect of the Companies Act 2006, as we indicated in our submissions yesterday, we accept that the effect of Section 172, subsection 3, is not to make it absolutely impossible for this court to overrule West Mercia. But as we said then, this court should be extremely slow to do so. Because if I can put it this way, perhaps rather colloquially, for which I apologise, Section 172, subsection 3 has effectively left a creditor interest shaped hole in the otherwise comprehensive codification of directors' duties. But the question for the court is essentially whether the common law fills that hole, and more pertinently, precisely how. And it's clear that in Section 172, that the Parliament has established a very different conception of the company as an enterprise in which various groups are interested, including creditors. And the question really in our submission to the court is whether creditors are just another constituency whose interests have to have regard paid to them under subsection 1, or whether they have some higher status, as suggested by the creditor-shaped hole left in subsection 3, so that they do have to be taken into account of at least equal status with members' interests on insolvency or close to it. And the point really here is that as regards the principle of the conception of the company created by section 172, that much is clear. It is a conception of the company which, unlike the Victorian conception of the company, clearly accommodates creditors' interests being taken into account, even to the extent of potentially in practice, on some occasions, taking priority over shareholders' interests, depending on the circumstances. So the point of principle is effectively settled in our submission by section 172, and the question for the court is, should that be the case, and if so, in precisely what way? But that is, as we've suggested, largely, or to a large extent at least, a pragmatic and policy question. Now, my learned friend asks, what's the difference between creditors and the other constituencies of interest identified, in particular in subsection 1 of section 172? And I'll answer that. One has to, of course, consider here the interests of the creditors as a body, collectively. There's no debate about that. And what we're looking at here is their interest in the company's enterprise, and therefore its assets, by virtue of a prospective administration or liquidation. This is essentially the quasi-proprietary rationale set out in Kinsella, because what that does in our submission is to identify exactly why creditors do have a higher status than these other constituencies of interest, sufficient, in appropriate circumstances, to be taken into account alongside members' interests and even occasionally to overcome them. Because we don't need to look back at the Kinsella passage again, but it is actually important to focus in our submission on what it actually identifies, because what it does identify is precisely why creditors have this higher status. Because what it points out is that in liquidation, one has a statutory scheme which takes the control of the company away from the shareholders. And it does so in the interest of the creditors collectively. It ends the enterprise, and it results in the realization of the assets for creditors. So we have here the displacement of the shareholders' collective control. We have an end to the enterprise, which has, to this point anyway, been pursued at least largely for the benefit of members. And the assets, which were previously being deployed for the benefit of members, are now realized exclusively for the benefit of creditors. And all this, of course, is fundamentally internal to the company. And it's this displacement of members' interests by creditors' interests pursuant to this statutory scheme, which explains precisely why creditors do have a significantly higher status than, for example, employees or the various other constituencies of interest identified in subsection 1. And so we basically say that the quasi-proprietary rationale is entirely sound for that reason. Now, my learned friend, I think, referred to the Worthington article, or one of them, suggesting that it is entirely flawed. And this is his reference to pages, we don't need to turn them up, 1 to 19 to 20. But if the court in due course looks at that, what Professor Worthington is saying is that, in her view, that rationale is flawed for 2 reasons. One, because the creditors do not acquire proprietary interests in liquidation. And that, of course, is correct, but really entirely beside the point. It's totally irrelevant. The quasi-proprietary rationale is not a statutory test. It's an explanation. It's an explanation for the result the law reaches. And Professor Worthington's second point was that the creditors, of course, in a liquidation have to give up their individual rights. But that's of no relevance. They do so, of course, as the price of a collective remedy through liquidation. Now, moving on to the next point, the respondents made various points regarding the criteria which the courts have identified in other cases to characterize or identify when there is a fiduciary relationship. They are, in our submission with respect, completely irrelevant, because that isn't the issue here. We know there's a fiduciary relationship. We know who it's between. It's between the company and the director. And the question is not about whether there is a fiduciary relationship. The question is about what is the content of that relationship. What is the content of that duty? I apologize. What is the content of that duty? And actually, what is the content of that duty in one very specific respect? So when, for example, the learned friend says, well, creditors don't entrust powers to the directors, and they don't have a relationship of trust and confidence with the directors, well, that may be entirely true, but it's completely irrelevant. It would be burningly relevant to a question of whether the directors might, in an unusual case, owe fiduciary duties directly to the creditors or to a particular creditor, but that's not the point here. And one should say, of course, in relation to those 2 points, the shareholders don't actually entrust their powers to the directors, and the shareholders don't have a relationship of trust and confidence with the directors either. It's the company that does. And of course, it's entirely common ground that we are focusing here on the director's duties owed to the company. So all that is a bit of a red herring in our submission. It is actually another instance of the respondent's case necessarily having to ignore the company as an entity and try to look through it and look at the shareholders. Now, then, if I may, I will pass on to some points made by my learned friend this morning. In relation to the question of whether the duty exists at all, my learned friend did accept that directors do, even on his case, have to take account of creditors' interests. But he says, well, that's only under subsection 1, section 172. Now, the problem with that, and this is his submission, is that if that is the position, directors do not ever give priority to creditors' interests over shareholders' interests. Shareholders' interests always, on his case, dominate. And if that is the position, then all of the practical issues and problems to which the creditor duty is directed are simply not going to be dealt with at all if that is the position. And for example, the problem that I submitted to the court would exist on his case as regards a conflict in section 214 and the duty that he says is always owed to pursue the interests of members exclusively would still exist. And of course, that duty that he posits, a duty that effectively puts creditors as another body of interest under subsection 1, is one that is exactly what is not contemplated by subsection 3, which expressly contemplates a duty to which subsection 1 is to be subject. Now, I think my learned friend also accepted in the course of submissions that on his case it might be possible that section 214 might be a rule of law or enactment caught by subsection 3, section 172, which might therefore modify section 172, subsection 1. But he didn't make it clear exactly how that might happen. And if that's the case, then again, unless that has the consequence that directors may prioritize in that section 214 type situation the interests of creditors over members, then that is not going to sit in harmony with section 214 at all. So if that is the case, as he began to accept, if section 214 is something that falls within subsection 3, it must follow that therefore, in that situation, directors can, fully in accordance with their duties, give priority to creditors' interests. And so that's effectively the creditor duty. Now, my lords, Lady Arden asked questions of my learned friend regarding the possibility that, at the very least, one might be able to distill from the various statutory interventions an organising principle which might fall within subsection 3 of section 172. Now, all that I would say in relation to that, without in any way recoiling from our rather more wide-ranging submissions, is that if that were the approach, even on a relatively narrow basis, one, of course, of the statutory provisions that would have to be encompassed within that search for an organising principle would be section 423. And as we know, in this case, at first instance, the learned judge found that the relevant dividend in May fell within section 423 and granted relief accordingly. And so if one does adopt that approach, then that would capture the facts in this case. Now, then, my lords, my lady, I would propose to make a few submissions about ratification, picking up the points that my learned friend made this morning in relation to that, or at least some of them. Now, in relation to this, my learned friend sought, in making one of his points, to effectively equate the power to decide whether to sue or not on behalf of the company with the power to ratify. Now, the limit on ratification, the limit on the power to ratify on behalf of the company in the shareholders, which we advocate, does not in any way affect the company's title to sue. If there is no ratification, for whatever reason, but including in a situation where, if we're right, the shareholders don't have power to ratify on behalf of the company, then of course the company can still sue. One cannot equate those two decisions, those two powers. They're simply different things. The company may at any point, acting through its board or through its shareholders, depending on its constitution, decide not to sue. But that is not the same thing as ratification. Ratification involves the unequivocal adoption of the transaction by the company and the release of liability, release of the claims that the company may have. The decision not to sue is of far less import. And the fact that the shareholders may not have been in a position in May 2009, in this case, if we're right, to ratify a decision, does not mean that the company didn't have title to sue. And it doesn't mean that the shareholders are going to have decided on behalf of the company that it should sue. And Lord Justice Russell in Bamford, the dictum relied upon by my learned friend on this, was not suggesting in any way that one could equate ratification and the decision to sue, and was certainly not suggesting that if shareholders did not have power to ratify, they can't have had power to sue. He simply wasn't dealing with the issue at hand at all. Now, the second point in relation to ratification is this. It is not our case, as my learned friend characterised it, that the creditors replace the shareholders as regards ratification, where the limitation on the shareholders' power to ratify, which we advocate, applies. The position is simply that the creditors have a sufficient interest, that the shareholders' power to ratify has to be limited because they are no longer solely interested in the company. in the way that they are if the company is amply solvent. And thirdly and relatedly, we accept that the reason that the shareholders generally have the power to ratify is because they are an organ of the company. We don't quibble with that. We are not saying that the reason that they normally have the power to ratify is simply because they are primarily interested in the company. But the point is this, that the limit on their general power to ratify, which we advocate, does arise from the fact that, at least at insolvency, and that of course is the question here at this stage in the argument, at least at insolvency, the shareholders are no longer the constituency solely interested in the company. The creditors are too, at least as much as the shareholders, if not more, and that is why, that is the justification for the limit on the power to ratify. And fourthly, we'd say in relation to that, contrary to learned friends submissions, there isn't any problem. It is unproblematic if it is the case, as we suggest, that temporarily the shareholders will lose their power to ratify on behalf of the company. As we submitted in opening submissions, it doesn't follow that the company can't ratify, because either in due course the company may return to ample solvency, in which case the shareholders can ratify on its behalf again, or if it slips into insolvency and an insolvency process, then the liquidator or the administrator can ratify. And it's absolutely unproblematic that there should be a temporary inability of the shareholders to ratify on behalf of the company. For example, one has that in the case of a fraud on the minority case, where, of course, the shareholders acting by majority cannot ratify. In such a case, of course, in a fraud on the minority case, in due course, if the company then went into liquidation, the liquidator would be able to ratify on behalf of the company. So there's nothing exceptional, unusual, or impossible to deal with in this limit on the shareholders' power to ratify on behalf of the company, which we advocate and which is, as we submitted in our opening submissions, established by authority. Now, my Lord Briggs asked my learned friend the question, well, what is your justification for arguing that we should overrule those authorities, identify a limit on the power in a situation of insolvency? Give a variety of answers. I'm not going to critique all of them, but just want to make a couple of points. He identified cases such as, well, I don't think he referred actually to rolled steel, but one of them is rolled steel, for example, where there is reference to fraud on the creditors as being the reason why ratification is by the shareholders is in some circumstances not possible. Now, what that's a reference to, of course, is not common law fraud, but equitable fraud. And actually, in our submission, that's a reference to exactly the sort of situation one has if the creditor duty is breached. In fact, rolled steel was cited in Kinsella just after the key passage that we've spent some time looking at on the same page, at page 1061, and cited specifically on this point, including specifically the passage referring to no ratification where it's fraud on the creditors. And my learned friend suggested that actually fraud on the creditor cases are really just restricted to unlawful dividends. Well, no, they're certainly not. Rolled steel was not an unlawful dividend case. He made that submission on the basis of a reference to Aveling Barford, the decision of Mr. Justice Hoffman, which was an unlawful dividend, a return of capital case. But nothing that Mr. Justice Hoffman, as he then was saying in that case, was restricted to cases of unlawful dividends.
His proposition was really quite wide, wasn't it, in Aveling Barford, from recollection, that it doesn't matter whether shareholders call it a dividend or something else, if it's in essence in substance a return on capital, then it will be unlawful.
My lady, yes. I mean, the main point in Evelyn Barfoot was precisely that doesn't matter what it's called, if it's in substance a distribution to shareholders, it's caught by the maintenance of capital rules. And the point that Mr. Justice Hoffman was making, which my learned friend alluded, was the point that if that is the case, then ratification is, of course, impossible. And he referred to it as an example of a fraud on the creditors, referring back, I think, to Ridge Securities and probably other cases. So what the point that he was making there was that although this isn't a fraud on the creditors in the sense of an insolvency case, he was saying that one can still treat it as a fraud on the creditors case because actually it's an unlawful return of capital. So what he was doing was slightly expanding the concept of fraud on creditors. He wasn't for a moment limiting it to maintenance of capital cases. And that's the respect in which
Thank you.
we suggest my learned friend was wrong. Now, my learned friend also made a point on the fraud. Well, he suggested that perhaps this was at least analogous to fraud on the power cases, and referred, I think at this point, to another article by Professor Worthington. I think suggesting that actually in identifying what's a fraud on the power, one has to look at the constitution of the company, because that is of course the primary means by which the power is given. But actually that is obviously one place one looks in trying to work out whether a power is being exercised for a purpose for which it hasn't been given, applying the fraud on the power doctrine. But as Professor Worthington herself notes in her article, and just for the court's reference, it's page 1205. In company cases, because of the nature of the powers that are granted to the statutory entity or granted through the statutory entity of the company, one is not restricted to simply looking at the constitution, but one must look at the statute as well. So one way of rationalising the limit on the power of shareholders to ratify is a closely analogous approach, which looks to the purpose of power and looks not just to the constitution for this purpose, but also to statute, which would of course include the director's duties and the creditor's duty via section 172 subsection 3. Now, moving on from ratification, unless the court has any particular questions on that, I would go on to what I think was my learned friend's third limb on the question of whether the creditor's duty exists, which is to refer to the Wincham case. I just very quickly, at least perhaps reiterate to some extent what we say about that case. As I indicated in our opening submissions, the issue there was actually whether shares had been paid up or whether the directors were still liable as shareholders to pay a call on those shares. And one can see that from the relief at first instance, just from the court's note at the end of the first instance judgment on 642. That was the relief granted. That was the relief sought. And the question in the court was, as is apparent from the top of page 643, whether the payment made for the shares was genuine or not, whether it was effective. It simply wasn't a breach of fiduciary duty claim at all. Now, it's true the Court of Appeal, in argument, in dealing with the arguments made to it, referred to the fact that although the directors were, to use the language that was current at the time, trustees for the company, they weren't trustees for the creditors. That's the bottom of 643, the passage that I think both sides have shown the court. And that was very much in response to the Vice-Chancellor's, which was to refer to their status as trustees for the company. But it's very important that Vice-Chancellor's reasoning was based simply on the directors being trustees for the company. The Vice-Chancellor wasn't suggesting at first instance that the directors were trustees for the creditors. And the most important point is that no one at that stage was suggesting that as part of the director's duties owed to the company, there was an obligation to take into account creditors' interests. Because that's entirely unsurprising in 1878, pre-Salomon, where simply a much narrower conception of the company was in place, and there was no suggestion that the director's duties might, as a matter of content, encompass taking into account creditors' interests. So effectively, the respondents are really just speculating about a claim that was simply never made in that case. And it's inevitable that if the common law develops, it leaves in its wake previous cases which might have been decided differently under the laws it develops, because different claims might have been made, but which were never in fact raised. Those cases, in that situation where the common law is developed, are obviously not authority against the development that has taken place. And in relation to the various articles that my learned friend referred to, which he invokes as criticisms of the creditor duty, I'm not going to go through them in detail, but they really fall into, the objections they make fall into two types. There's an objection of principle, which is always basically to say shareholders are prime at all times, even in the case of insolvency. In our respectful submission, that is not correct. That's the only point of principle there is, and it's wrong. And the other objection they tend to make is basically one of policy, where they say for one reason or another they don't think that the creditor duty, is necessary. Well, that's a practical and policy question, but in our submission we've shown ample reasons why, as part of the common law, the creditor duty is more than necessary. So, Lady my Lord, that deals with that particular point regarding Winsham. We reiterate the point in respectful agreement with the point put to my learned friend by my Lord Hodge, that section 172 subsection 3 does indeed very clearly acknowledge the existence of the West Mercia rule. And what Parliament in our submission is doing in section 172 subsection 3 is acknowledging the law as it stood, which very clearly includes a creditor duty in the case of actual insolvency, and contemplating the development of the law by the courts beyond that.
Mr. Thompson, the fact that Mr. Rabinovitz finished early doesn't mean that you have additional time.
Ah, right. I will.
You've been.
How long have I been?
Speaking now for just over half an hour.
Ah,
So you could aim to come to a close soon, please.
certainly. Well, let me just deal then with one further case just on this point. Pick up a point that my Lord Briggs just put to my learned friend this morning in relation to the payment of a dividend that produced cash flow insolvency. My learned friend's answer to that is that, well, that can all be dealt with under section 172 subsection 1. Well, that in our respectful submission is clearly not an answer at all, because if, as my learned friend suggests, the creditor duty doesn't exist, it will follow that ratification by shareholders is possible. So the consequence of my learned friend's submission on that is that directors, if they are in breach of duty, whether it's under 171, just under 172 subsection 1, shareholders are, on his case, able to ratify that situation, despite the fact that that creates cash flow insolvency. And in our submission, that plainly can't be right. That, of course, is a point taken by the Court of Appeal in dismissing that argument put forward on respondents. So, Lord Malini, I apologise for going slightly over time, but if the court has any questions, obviously, I would be very happy to deal.
There don't appear to be any questions for you, Mr. Thompson. So thank you very much. We're grateful to you and to Mr. Rabinowitz and all those who assisted you in putting together your submissions, both orally and in writing. I'm sorry, I think I've been having problems with my microphone. We're most grateful to all those, both those who've spoken and also those behind the scenes who've assisted you for the submissions we've received. This is obviously not only an interesting but a very important case, and we'll now take time to consider the submissions that we've heard. We'll issue our judgment in writing in due course, and the court will now adjourn.